Imagine getting sanctioned by a federal judge because your LLM AI assistant decided to make things up. For one junior associate, that nightmare became a reality, and it threatened to cater his entire career, including the law firm itself. What I'm sharing today is a story playing out in real courtrooms right now, with devastating results for the lawyer who put too much faith into technology that they really don't fully understand. Now, how can a piece of AI LLM software hailed as a revolution for productivity in the modern times that we live in can bring a multi-million law firms to its knees? The answer is the phenomena technology insiders politely call as hallucination, as we know it, which is a term for when AI confidently serves you fiction like it is a fact. This is a story of a fictional law firm called Sterling, Archer, and Reed. It's about a promise of AI and the catastrophic blind trust in the technology, and the line in between the innovation and malpractices when it gets dangerously blurry. The story follows a predictable pattern, and once you see it, you'll spot where AI actually goes wrong. In fact, not only just AI, but also where human beings go wrong. Sterling Archer is a pillar of legal community. They have the mahogany panel rooms, decades of courtroom wins, but the reality is behind the facade, the firm is actually struggling. The younger competitive firms are working faster and cheaper, and the associates are drowning in this firm in paperwork, and the pressure is building on. Now meet David Sterling, who is the managing partner of this firm. He's a brilliant lawyer who is an old guard, who knows the firm has to modernize or is going to be eliminated. He's hunting for that silver bullet. He thinks he found it in the form of the modern LLMs. At a firm-wide meeting, David unveils a sleek logo of this LLM that they plan to use and the promise of the new era of AI. He quotes the slogan, "This is the end of the grunt work. This is going to be your 24/7 legal genius that's available to you that can draft motions in minutes." He's calling it confidential AI. And he explains that this is not just a research software. It's actually a generative software. It analyzes the document, summarizes the disposition, and drafts original legal argument. He announces a major investment in this technology firm-wide, and everyone is going to have access to it, and they can start using it immediately. In this crowd, there is a young attorney, Alex Chen, who is an associate. He's very smart and ambitious, but he's exhausted because he has a lot of work on his plate. And for him, AI not only sounds like a tool, but it sounds like a lifeline to save him from the failure. So the failure point one here is the blind institutional trust in the legal genius, which should not happen. The case that would change everything was a company lawsuit. The stakes were really enormous, and the client was demanding. 2 weeks after the AI rollout, the opposing counsel filed a massive motion for the summary judgment. The deadline was only 10 days, so it's a very short and squeezed period. Apparently, the job landed on Alex's plate. His supervising partner was a very blunt but very strong attorney, who's Sarah. She said, "Sure, this is our one short, Alex. Every citation needs to be perfect. Use everything that we have got. I want to see what you can do with this new AI tool." Alex spent 3 days buried in binders, drowning in evidence, and the progress was very slow and kind of mundane. Late on the fourth night, Alex was exhausted and he decided to open this confidential AI. He typed in a complex query about trade dress protection in the Second Circuit. And he started looking at the output of the AI, which AI output was very much instantaneous with appropriate citations. It looked amazing, which was polished, persuasive analysis filled with publicly plausible clause citations, and some of them were like Synergy Software, Phoenix Solution, Martinez versus Global Data Corp. It felt like real magic, and Alex was really excited. Alex did a quick run check. One case didn't appear, and Alex thought that may have been a technological mistake, so he didn't bother to check all the remaining citations in that document, because the AI sounded very confident and the deadline was booming on Alex's face. He didn't check the rest of the arguments, and he just copied that entire AI generated analysis and put that into the document. The only edits that he made was probably the title section, maybe the beginning abstract and the end of it, and pasted into the firm's brief. At this point of time, the software had already failed. We don't just have incorrect information, because we all have incorrect citation, which is a major issue. So he cleaned up the formatting and sent it up the chain. At this moment, the verification gap opens up not because of AI, but because of how humans behave under pressure. And this is called as automation pressure. The brief was filed hours before the deadline, and Alex felt a sigh of relief, and his partner skimmed, "This looks good." For a few days, everything was good. Now, the opposing counsel, they began dissecting the citation. A veteran paralegal named Maria ran the first case, and she did not found anything in the system. She checked again. There was still nothing. And one by one, she searched all the 8 cases that were mentioned in this document, and none of them actually existed. At first, she thought that this might be just some error of some sort. But these weren't just mistakes. These were fabrications of putting cases that never really existed. The opposing firm didn't just file a reply. They actually filed a Rule 11 motion for sanctions, accusing Sterling Archer and Reed of a professional misconduct. Once the bluff is filed, it actually becomes an evidence. There's no going back after that. The courtroom was completely silent during the case day. Judge Eleanor Vance held up the brief. My law clerk couldn't find these cases. Opposing counsel couldn't find them. Mr. Chen, where did they come from? That was her question directly to Alex Chen. There was nowhere to hide at this point of time. Your Honor, I used an AI search platform. The judge was not really impressed by it because the rulings are very clear. So she asked, are you telling the court you copy-pasted legal arguments without verifying the cases were real? She didn't wait for the answer, and she went even further. The lawyers who sign a filing is responsible for it, not your firm, not a piece of software. Your ethical duties are non-negotiable. This technology is prone to hallucination, and you must be aware of that, and you serve code a fictitious document. She granted the sanctions, and there were fines and fees, and there were also a public written order against the firm as well as Alex, which is going to be a permanent stain on this organization. This is where the non-delegable duty collides with the real world, and it becomes absolutely painful for this law firm. The client fired the firm within the hour and announced a plan to recover the damages as well, which can be potentially devastating. A malpractice lawsuit was also inevitable. Tens of millions of dollars are now at stake. For what? For using AI to do the work. The legal blogs and news channel, they erupted, and the insurance called. The premium started spiking for the law firm, and there was a potential that they might never even get insured. Alex Chen's career was effectively over. The sanctions ordered would follow him forever, which is also going to include a bar from referral boomed. So how did this really happen? Not because the AI was evil and it has some kind of agenda, and not because the firm was reckless. It happened because of 2 forces were colliding to each other. A system designed to guess confidently, and a profession where responsibility cannot be delegated. I repeat, responsibility cannot be delegated. So LLMs are not just the databases of truth. They are predictive engines. They're optimized to produce plausible answers. When they don't know, they raise the hand and they start bluffing. When Alex asked for a case, the AI didn't find any related case to support his argument. So it generated a text that looks right, sounded right, and was delivered with very, very high degree of confidence. That's not a bug. This is how the system is trained. These models are trained to behave. As a matter of fact, in 2024, OpenAI published a detailed research study called Why Language Models Hallucinate. The finding is basically very uncomfortable to swallow. In fact, what we learned from that finding is the models are rewarded for confident answers. They're not rewarded for truthful, certain behavior. It doesn't tell you that I don't know, because it's not going to get rewarded for it. It is going to earn points if it starts guessing. So hallucinations are not glitches. They are predictable outcomes on how the models are supposed to work, which means no branding, no pricing tiers or legal fine-tuning changes the underlying behavior or how LLMs operate. Now, there are cases where you can use solutions like TrueLens to take care of hallucination to a degree, but you cannot make it 100% foolproof. The real failure at Sterling Archer and Reed is not because that they were using AI, because it was treating AI output knowledge instead of what it is, a statistical plausible guess. Verification in AI is not optional. It is a missing incentive that the system does not have, and it's mandatory. The human oversight is mandatory. Until models are trained to prefer to say, I don't know, The responsibility sits entirely with the profession, in this case, the legal firm. And in your case, whatever your organization and company is, it's on you. So Alex didn't just miss the citation check. He stepped into a system directly and exactly what it's designed to do, and it failed to supply the one thing that it cannot provide. So here's the checklist for you. Do verify every fact, quote, and citation from AI. Don't paste unverified AI output into real filing. Use the tool to show the sources explicitly and still verify it. Implement a firm-wide training, policies, guidelines, and guardrails to AI. There is no ban to AI yet, and it's not going to be, because AI is just like email. We need to start use more and more. But from what we learned from this particular firm, the consequences are going to be real. Even though Sterling Archer and Reed is a fictional firm, you cannot escape from the consequences. There are cases like Mata versus Avianca. They already proved this is real, and the number of cases that are impacted by Gen AI impact is growing. So what do you think? Is the legal profession moving too fast, or these are just growth pains in the legal technology? Let me know in your comments. And if you want to really understand how the AI hallucination works, you can watch my next video that is showing up in the screen.